Hey there, welcome back to our series on human resource management. Today we're talking about HR legal. Yeah, this is big. I said in a previous video that HR is kind of like this de facto arm of legal. Well, today we're going to talk about what that means. So there's a lot to go over. It's going to be kind of a long video, and even then we're not even going to scratch the surface. You can take whole courses on this stuff. So, we're going to do our best, but we're going to fly through it. Hang out with us because this is important. I'll see you in the presentation. Okay, so let's go ahead and jump into the legal environment of HR. Now, the first thing we need to do is talk about discrimination. Now, I know that might sound like a non sequitur, but believe me, this will make sense because in many ways, the crux of HR legal issues, laws, rules, regulations hinges around the principle of discrimination. So with that, let me share a thought with you. We don't establish discrimination laws protecting those with whom we naturally agree and embrace. So, in other words, you won't see much in the way of legislation protecting young white male professionals that love their mothers, church, country, apple pie, and the Dallas Cowboys. Discrimination laws, rules, and regulations are really in place to protect those with whom we do not necessarily agree. So with that in mind, let's move forward. And let's define discrimination for HR. So discrimination occurs when an employee or a job applicant is treated unfairly because of this person's race, gender, nationality, religion, age, disability, or familial status, such as whether or not they have children or are pregnant. Now, there's also the idea of reverse discrimination. This occurs when members of the majority class, or those who are historically enjoying advantage in the environment, are discriminated against based on their race, gender, age, or other protected characteristics. So, for example, when a person is denied an opportunity because of preferences given to protected class individuals who may be less qualified. That is an example of reverse discrimination. Now, one way that discrimination takes place is in disparate treatment. So those at the Equal Opportunity Department or whatever define this type of discrimination as inconsistent application of rules and policies to one group of people over another. So this occurs when an employer intentionally treats one class differently from another, not better or worse, just differently, because they belong to that class. So for example, requiring a job applicant in a protected group to take an additional assessment test not required of other job applicants who are outside of that protected group. So for instance, if I'm hiring somebody and I say, oh, you're a male? Okay, here's all the assessment tests you need to take. Oh, you're female? There's an additional test I need you to take. That would be an example of disparate treatment. There's also adverse impact or disparate impact. This is when an HR policy or practice appears to be neutral but has an unintended discriminatory effect on a protected group. So it shows employment discrimination based on the effect of the employment policy or practice rather than the intent behind it. So let me give you this example. Height requirements. Some height requirements may discriminate against women or some nationalities. Height is not a protected class, and so the policy doesn't say anything about gender or nationality, and so it can be considered neutral, or it is a neutral policy. But it may inadvertently discriminate against those in protected groups. Okay, so with those sort of definitions of discrimination in place, let's dig right into all the legal history behind our journey to equal opportunity, which, by the way, we have not hit yet. We'll talk about that. So to begin with, let's talk about the 1964 Civil Rights Act. This act outlawed racial segregation and discrimination in employment, public facilities, and education. It included race, color, religion, national origin, and gender. So we could go into all of these, but we're not going to. So let's just explore for a moment race and color. Race and color can include things like skin color, hair texture, facial features, name, attire, accent, marriage to a minority, things of that nature. Now, once again, we could go way deep into each one of these. Not going to happen. So let's just look at, say, name and attire. Many studies have shown that those with a name that is foreign or outside of the majority class are often discriminated against when it comes to getting jobs. So many studies have been done to show that if I send in two absolutely identical resumes for a job, and one of them says John and the other one says Mohammed, there is a very good chance that John will get the phone call asking for an interview, whereas Mohammed may hear nothing. That is an example of name discrimination. Attire discrimination is very common today as well. We have lots of controversy around wearing, say, the hijab or other attire that is associated with race or religion or things of that nature. We cannot discriminate based on attire when it is part of a protected class. Now, coming back to the 1964 Civil Rights Act, let's now do a little bit more of an explore on religion. Now, an interesting thing about religion, this is when we discriminate against people based on their religious beliefs or how they're practiced. One thing to bear in mind is all religions are covered. There's absolutely no law saying what religions are covered and what religions are not. So long as the person practicing the religion exercises sincere belief in that religion, it is protected. So, for example, let's look at Festivus. Here's an article you can go ahead and search for if you want that basically talks about a court case in which Festivus was protected for a prisoner. One of the quotes from this article here on the side says, "The government doesn't maintain some master list of legitimate religions or religious beliefs, and the government isn't in the business of recognizing religions. Contrary to some popular assumptions, your belief system doesn't automatically get official recognition if you accumulate a certain number of followers, because in the United States, there is no valid or invalid religions." So, yes, you have to recognize all religions if they are sincerely held by the employee. Now, if you want to have some more fun with this, go ahead and Google Church of the Flying Spaghetti Monster. Okay, coming back to our Civil Rights Act, let's now do a little bit of a deep dive in national origin. This is when we discriminate against people based on, well, where they're from, their national origin. And this can include things like name, dress, and even accent. Yes, sometimes when you do a telephone interview with somebody or another, you may hear an accent that'll suggest a given national origin. You cannot discriminate against a person based on that. Now let's look at sex and gender discrimination. Examples of sex and gender discrimination can include things around wages and benefits, procedures, leave of absence, dress codes, job categories, things like that. Let's go ahead and take a look at wages and benefits. According to the Equal Pay Act of 1963, you cannot pay a male more or differently than a female. So all pay should be equal so long as the jobs are substantially equal. I got news for you. That isn't the way it works. And this is an ongoing problem that we're struggling with. So if this law says it's illegal to pay a woman, say, 80 cents on the dollar, which is round about the average, why does it happen? Well, there's a whole variety of reasons that happens, and one of these days I need to do a separate video aimed at both men and women to talk about how we can fight this issue. So women are often the ones who are expected to take care of the kids even when they're working. There's a great story in which Justice Ruth Bader Ginsburg tells she and her husband had this kid in high school, and every single time the kid got in trouble, they would call Ruth Bader Ginsburg. They would call the mother, call the mother. You always call the mother, call the mother. And she one time told the principal, listen, this kid has two parents. I want you to change the person you call every other time. But the assumption is that that's the mother's job. Same thing goes with taking the kid off to doctor visits or to games and so on and so forth. It's always kind of assumed that the mother does this. Well, so what? What's the problem? Here's the problem, is that reduces the face time and it gives the impression that work is not a priority. So if the mother is the one who's always having to leave early or leave in the middle of the day to take care of something, then that reduces the amount of time that the mother can sit there or the woman can get the work done, work with her coworkers, collaborate, basically influence leadership. If they're not there, they can't do these things. Meanwhile, the guy, he's there working 60 hours a week. He's putting in lots of face time, building those relationships, expanding that network, insinuating himself into the company. That's going to increase the perception of value on his part. Furthermore, if the mother is the one always running off and getting the kids and so forth, that encourages the perception that, oh, work is just kind of this nice little side gig I do. The kids are the priority. Whereas fathers, oh, they can ignore the kid all day long. Work is the priority. This is something that needs to be broken. We need to change this. Furthermore, another example is when you negotiate your first salary. Men are awful at negotiating. Women are super awful at negotiating their first salary. Now, of course, I'm talking in generalities here, but bear with me. If a male, for his first salary coming out of college, negotiates, say, $30,000 a year, but a female negotiates $29,000 a year, well, that's only a $1,000 difference. That's not a big difference. But no, you track that over 30 years with, say, a 3 to 5% increase year after year. And all of a sudden, when you're in your peak earning period, the woman is earning substantially less than the male. Now, I could go on. I need to make another video about this because this is important. The point is, we need to fight this thing because it should be equal pay for equal work. Okay, getting off my soapbox there. Now, there's also the Pregnancy Discrimination Act of 1978. Basically says that pregnancy may not be considered in employment decisions around hiring, insurance, leaves, work conditions, things of that nature. Once again, this is what the law says, but it doesn't always happen in practice. I know many hiring managers who might be sitting across the desk from a young woman who's pregnant and thinking to him or herself, well, gee, am I going to have to give you medical leave here in, 3 months, and then you're going to be gone for 6 months, and then you're going to, have to be in and out of the office to take care of the child and do have daycare, so on and so forth. That's not allowed. It is not legal for the hiring manager to wonder, let alone ask about those things. If you, as a woman, have ever been asked by a hiring manager, hey, so do you have, daycare all set up? Are you going to have that all situated? That is an illegal question. You're not allowed to ask about it. Equal opportunity for everyone. Okay, now a quick plug for the 1972 amendment. The EEOC, the Equal Employment Opportunity Commission, basically put teeth around the 1964 Civil Rights Act. You see, that Civil Rights Act was passed, but there wasn't really any teeth to the enforcement. You could go ahead and break the law and there was no big deal. Well, this amendment took care of that problem. Also expanded the scope of civil rights protection to employees of local and state governments and education and labor. And then another quick act, the 1967 Age Discrimination and Employment Act, protects anybody over 40 years old, stops companies from requiring mandatory retirement age, depending on the industry, but that's generally the case across the board. It also says you need to be careful that you don't set up discriminatory practices around fitness requirements that are not relevant to the position or different health benefits offered to folks who are older. You don't want to change job requirements or lay off workers who are older just because you're targeting older workers. Okay, now let's talk about the Americans with Disabilities Act. This is the good old ADA of 1990. It extends protection and reasonable accommodations to those with a disability. First, let's define disability. Somebody who has a physical or mental impairment that substantially limits one or more life activities, has a history or record of such impairment, and is perceived by others as having such an impairment. Those are folks that have a disability. Now, that might feel awfully broad, and in truth it is, but it's broad for a reason. We actually have to assess each situation individually. And in assessing these situations individually, here are some important terms to know. First of all, you have qualified individuals, those who meet the requirements that we just talked about before. Major life activity. So remember, it said, well, it limits my major life activity. This includes seeing, hearing, eating, walking, standing, breathing, concentrating, things like that. Essential job functions. Activities explained in the job description that are required for success in the position. Now, later on, we're going to be talking about setting up job descriptions, writing job descriptions. And one of the things we're going to say is it's important that you include things in the job description that are directly related to the job and not ancillary to the job, because you don't want to get mixed up with the ADA. Finally, reasonable accommodation. Modifications to the work environment that allow a qualified individual to work, relevant to the size of the organization. Not everybody needs to follow the ADA, and may include wider doorways, ramps, adaptive software, modified work schedules, and many other things. So when you see ramps going up to front doors in businesses, that's an ADA accommodation. Okay, now that we've defined discrimination and talked about how these various acts and amendments and laws sort of set the parameters around what is discriminatory behavior, let's talk specifically about preventing discrimination. Now, there are 4 tests that are commonly used to decide whether or not a company is acting in a discriminatory fashion. Let's look at these 4 tests. The first is called the 4/5 rule. Now, by the way, I'm not good at math, so I'm just going to kind of talk you through this, but bear with me. We'll get to sort of the spirit of the math in a moment. Okay, so 4/5 rule. Proportion of minority members hired must equal at least 80%, 4/5, of the majority members in the hired population. So for example, let's say that you have 9 positions to fill. 100 people apply, 60 are male, and 40 are female. That means that you should hire 5 males and 4 females. If you do this, now of course, it's not a quota system that you set up for every single hire. This is what the company is experiencing in general. But if you do this, you would meet the 4/5 rule. Now, here are 2 more rules: restricted policy and geographical comparisons. First, restricted policy is making sure that your HR management policies do not exclude a protected class of individuals. So you can't say overtly, we don't hire people from Malaysia. We don't hire people under 5'2". We don't hire people who have black hair. You can't do that. Furthermore, your policies need to be equally applicable to everybody in the organization, not different classes, because then you'd have disparate treatment. Geographical Comparisons ask the question of whether or not a company's mix of employees reflect its recruiting market. Meaning, okay, if my recruiting market is a 20-mile radius around me, I want to look at the demographic profile of everybody living in that 20-mile radius. And my mix of employees should match that mix of people in the population in that 20-mile radius. So there you go. The last test is the McDonnell-Douglas test. 4 components must exist for discrimination to exist. Individual is a member of a protected group. Individual applied for a job for which he or she was qualified. Individual was rejected. And 4th, the employer continued to seek applicants with similar qualification after the individual was rejected. So if I'm hiring somebody and you come along and you're part of a protected class, let's say that you're Latina, okay? I go, well, yeah, you have all the qualifications. I look at the resume, I talk with you, you have all the qualifications, you're great, you're fantastic, but, oh man, I don't want to hire a Latina. So I'm going to make up some bullcrap answer like, oh, well, you know what, sorry, but you don't quite meet the qualifications, which is totally baloney. So I'm going to send you out the door, and then I'm going to keep advertising and soliciting for applicants for the very same job. That is discrimination. You can't do that. Okay, so how do we prevent all this? These are, 4 rules that kind of show, hey, if you're doing these things, you're either clean in terms of discrimination or you're in trouble. Well, companies should have affirmative action plans. These plans seek to correct past injustices by hiring and actively seeking after minority applicants. The workforce should resemble the community. We talked about that. And by the way, if you are applying for government contracts with the federal government, you have to have in place an affirmative action plan. Okay, let's move on and let's talk about sexual harassment, something that unfortunately, as we've seen from the Me Too movement, is very, very common. So let's talk about what it means. So sexual harassment, let's first define it. It creates an intimidating, offensive, or hostile work environment for the individual. It unreasonably interferes with the individual's work, and it adversely affects an individual's employment opportunities, meaning you're not going to get a promotion until you play ball. That is what is considered sexual harassment. Now, there's 2 flavors of sexual harassment. We have quid pro quo and we have hostile environment harassment. Let's first talk quid pro quo. This is when sexual behavior is expected as a condition of employment. It says, listen, if you want to work here, you have to do these favors. That is a quid pro quo. All right, just expect it as part of you being here. Hostile environment harassment, on the other hand, is when the workplace environment is offensive enough to interfere with the ability of an employee to do their work. So, as I said, this is pretty common. You're going to get a lot of training on sexual harassment in the workplace when you're hired on, and occasionally each year when they want to make sure that people understand what appropriate behavior is and what the expectations of the company are. Pay attention to these things. Everybody should feel absolutely safe when at work, and sexual harassment absolutely cannot be tolerated as it gets in the way of people doing their job and feeling safe and basically thriving as an individual. Okay, now let's talk about some employee rights legislation. One piece of legislation is called the Employment at Will Doctrine. The idea here is that it allows companies to fire employees at any time for any reason except for things like race, religion, sex, nationality, things of that nature, disability. So, yeah, it's firing without cause. I can let you go at absolutely any time. Now, on one hand, that sounds pretty darned awful for the employee and pretty awesome for the employer. And spoiler alert, it is. But there is another side to this coin, and that's right to work. This allows people to work without being a member of a union. Now, in today's world, that may not be such a big deal, but in some parts of the country, especially if you go out east, it still is a pretty significant concept. The idea here is that you have a right to work. You have that right to work. You do not need to join a union. You do not need to pay dues to this group. You do not need to affiliate with these organizations in order to work. You have a right to work. So that's kind of the other side of the coin. We also want to talk about workplace security and employee privacy. Now, companies have the right to want a secure workplace. They want to look out against theft or revealing trade secrets to its competitors. Using the customer database for personal gain is something they want to avoid. They don't want to lose productivity. And so, basically, HR has the right to monitor your email, internet use, phone. Think of it this way. It's not your internet. It's not your computer. It's not your time. It's not your phone. It is the company's internet. It is the company's computer. It is the company's email server. It is the company's phone. It is the company's time. They're paying you for it. Therefore, they have the right to monitor these things to make sure that they have a secure workplace. That said, you do have a certain level of privacy and access to your information. So, for instance, the Privacy Act of 1974 requires government agencies to make information contained in their personnel files available to employees. And employees can review letters of recommendation made on their behalf, and many similar state laws apply to state and private sector employees. So, for instance, your employer has a file on you. This goes in your permanent record, that sort of thing. You have the right to see everything that's in that file. You can go to your manager, you can go to HR at any time and say, I want to see what's in my file. We also have the Drug-Free Workplace Act of 1988. You can imagine what this is. It requires government agencies, federal contractors, and those receiving federal funds to establish and disseminate drug-free policies and provide substance abuse awareness programs. Drug-free policies have to include things like what is expected of employees, penalties for infractions, and substance abuse awareness programs. And by the way, you have a personal life, and sometimes it goes to work with you, and so you might have workplace romances bubbling up. Well, this is pretty concerning, actually, to an employer. Concerns include things like favoritism or ethical issues, low productivity, morale problems, and workplace violence. So some companies may forbid co-worker relationships and have fraternization. There's the word. Hey, I did it right once. We're going to leave it alone. That thing policies. Also, they may require consensual relationship contracts, where they want to make sure that it is not some sort of, glossed over sexual harassment going on. Of course, workplace romances happen. There's no way of avoiding them really, but companies do keep an eye on them, and they do get nervous. Finally, we want to look at discipline and employee rights around workplace discipline. The principle here is that employees should conduct themselves according to organizational rules and standards. However, you need to be made aware of what these standards are and what is expected, and they need to know that meeting these expectations is in the best interest of both themselves and the organization. Now, when a manager wants to discipline an employee, there are some things that manager had better really think about before he or she does anything. And by the way, they should also always turn to HR to make sure that they're doing the right thing from a legal perspective. They need to consider the seriousness of the problem, the duration of the problem, the frequency and nature of the problem, extenuating factors or degree of socialization, history of the organization's discipline practices, and management backing. So let me just give you a quick example. If it's not a serious problem, it's not continuing on, it only happened once, and it's not a big deal, and the fact of the matter is there were some extenuating factors going on, and the degree of socialization, meaning nobody knows about it and nobody needs to know about it. And frankly, we've had far worse things happen in the past than we've done nothing about it. And you know what? If I run this up the flagpole and talk to HR, they're going to say, no, you don't have our backing, leave it alone. In that case, no, nothing should be done. But holy heck, if it's serious and it's ongoing and it happens all the time and there's nothing extenuating about it and everybody knows about it and we have disciplined far less than this sort of thing, yeah, management's going to back it and they're going to exercise discipline. And so, you know what? I know that was a really quick drive-by, but hey, if you're still watching now, good for you. Now, back to the studio. All right, there you go. And like I said, that's not even a taste of everything involved. Nevertheless, it gives you some sort of idea of how symbiotic the relationship between HR and legal can be. All right, stick with us. We have a lot more to go over. Have a great day.